Okay, welcome. Those online, over here in the room. We'd like to call this meeting to order. It is Moore City Planning Commission meeting, August 20th, 2024. This is a work session. I'd like to call it to order. First time might be for us to elect a chair pro tem. If there's a motion to do that.
Make a motion that we select a chair pro tem.
As in who?
Pardon me?
You want to name someone?
Oh, I think you want us to name someone that's here.
Yeah.
Okay, I make the motion that we select a
Chair pro tem.
chair pro tem. I suggest that we elect Eric.
Oh.
No, to you.
Yeah, it can be Ray.
Ray Little.
Okay, so
I second that.
the move in second, we select Chair Pro Tem for the work session. We nominated Ray Little to fill that position. Is there any discussion? Seeing none, proceed to vote. All in favor? Jason? Okay, all in favor. Thank you. Okay. Work session, we're just going to review the items on the agenda. Jake, we'll turn it over to you, if you will, or you and Gary to discuss that with us, please.
Yes.
Good evening, Planning Commission. Great to be with you. So I can do an overview of our rezone project that we have on the agenda tonight. And then also cover a couple items that we'll want to discuss in the main session on the subdivision. I would propose that the order be, I cover the rezone. And then we have Gary talking a little bit on training tonight. And so I would suggest that be item number 2 in the work session, and then item number 3 would be the subdivision.
No, I would accept that
Okay.
order of agenda, so thank you.
Okay, great. Well, I'm going to do a screen share here and I'll pull up my screen. Okay. So this is the report that you received last week. I do have a couple updates that actually came in today from the applicant, so I'm going to share those. They don't substantially change the project in any way, but they do bring just a little bit information, additional light. I'm going to go ahead and go to the maps, but the request is the north part of the property be R10 and then the south part be R12. And we'll come back to my recommendations in a minute.
Why would they do that? Do you want bigger lot on part of the subdivision?
Yes,
Okay.
yes. So this is the entire property located in the southwest area of the city. Currently, it's zoned agriculture, and that is the use. I went out and did a site visit and saw alfalfa or whatever was growing. I wasn't paying too, I was looking at the utilities and the layout and all that, but certainly it was a farm. And there's a number of parcels included in this request, not just a single parcel, but multiple. So those are the parcels included. So this north area is what is being requested as R110. And I'm going to show you one slight difference. In fact, I'll just sketch on here so you can see this. So the official request on the rezone is according to the property description, the parcels in the property description, and the property description has not changed. The applicant did not provide. They said that was accurate. What did come in different is actually, and we had Matt double check this, our city engineer. You'll see this on a different map. But this is the actual area for R10. So if you notice, it's a little bit farther north. So just down from 525. Just want to bring that to your attention. You'll see that on a different map, and that'll be submitted as part of the public record as well. So the southern area is R112 according to their request, and it goes down to the city boundary. and also, down to Canyon Creek is the southern border of the request. So this is the property in yellow. And then on it, surrounding, we have all different zone types. We have R112 in blue. We have R18 in this lighter color that just kind of touches a kitty corner here. And then we have some ag as well. And then we also have unincorporated county. And then we have R110 here on the east. And then R120 also corner touching. So a lot of different options, or a lot of different zoning areas
Jay,
on the perimeter.
on that map, one quick question.
Yep.
This will create two islands. That's still okay?
Yeah.
Ag islands.
It is okay. I mean,
Okay.
we already have existing islands in the area. And you know, in planning theory, islands are not good, but when you drive through neighborhoods and you look at subdivisions, you don't see zoning maps. You see homes and neighborhoods, and if streets connect and, you know, public health, safety, and welfare is covered, then I think it's okay. And also with our general plan, you know, we have a 20-year vision. So it's, you know, what's on the ground with zoning doesn't have to match up for a rezone. If that makes sense. We're looking at this long view down the road. But it is important to know what's surrounding. Okay, this is the map that was provided with the application that you saw in the packet. And then this is the updated map that they provided today when double checking. And so I'm just going to zoom in. Trying to. Here we go. So you'll notice it comes in at this first parcel.
Okay.
So question,
Yep.
will the primary access be 525 west and 400 west? Be two access points?
Yes,
Oh,
and also we can stub out additional access point to
Oh.
future connection to Webster.
Also,
Okay.
also by the end of Pheasant Run, that one will become a road too.
Oh, where's Pheasant Run?
You know where the little triangle at the top, right?
Yeah,
Right there is where the.
Move your mouse down, down, down.
because
down.
we do have this 350 as well.
Move your mouse down.
That's that new subdivision that's
Okay,
right
now
there.
come straight across.
To which way? Sorry.
So if you look,
Right
it's
here?
this right there.
Okay, so Pheasant Run and then 520. So at least 4 and potentially additional. But street connections will come at subdivision level. It's good to know that there's access. I mean, let's just say this was surrounded by 10 cul-de-sacs and there was no way in. Well, maybe we actually wouldn't, you know, that would be a reason not to be in favor of a rezone. But because there is multiple access points and the general plan does cover them, then you can say there is access. So this was just provided today, but I want to include this for the public record.
Jake,
And for your
did you,
information.
did you say that change is the same as their description?
This
the-
one actually matches the
the
legal description. We had Matt Harvickson, our city
So
engineer.
the acres and the description as in your notes.
Yes.
matches this new map.
Yes, we had him verify that.
Thank you.
So. Okay, so this is what the general plan shows. Spent all this work on it. The MDR, medium density residential, is this kind of sand color. And then this lighter yellow is the LDR, low density residential. And we'll get to the general plan in a minute, but, you know, the general plan is general. It's not required to follow it exactly. It is advisory. And also, in many cases in our general plan, it doesn't necessarily follow property lines. You know, it's up to the interpretation of the land use authority, which is the planning commission. And actually, and ultimately the city council on a rezone. So I did bring in the text here. This is the text from our general plan. Low density is 2 to 3 units per acre. And medium density is 3 to 5. And in addition, you have to remember these are gross densities. So you're adding right away. So essentially 25%. You know, a 60-foot right of way is about 25%, give or take. So it actually is, if you look at net density, these are actually a little bit higher than the 2 to 3 or the 3 to 5. And that was clearly spelled out in the general plan, and we did talk about it during the general plan time. And it's weird because, let me just explain, in general plan and kind of big picture planning, you want to look at gross densities because you don't know what all the roads are going to do, parks, trails, in our case, rivers, creeks, railroad, 84, all of that. So you look at this gross density, and then when you get to a subdivision level, that's when you go to more the net density, because you may or may not be taking out the streets. Okay, this is the text that was included in the general plan. Densities shown in this chapter represent gross densities, meaning streets, rights of way, and common areas are included. So, okay, this is what was included in your packet. The general plan, MDR here in the tan, and then the LDR in the yellow, and then the proposed zone boundary. And I'm gonna skip down one page because I pulled in and matched it. So this purple line is actually what was in the legal description and also what is proposed. It kind of gives you a better idea. So yes, there is some discrepancy there, but the general plan is advisory. The interpretation is up to planning commission recommendation and city council vote. And what you can do after the fact is we can choose to leave it as is, or the planning commission could recommend, let's go ahead and update our future. If you accept these changes, the planning commission could recommend that we update the future land use, this map. So we just come back with an updated map to match up. That's the second option. And that could be tied with future items, or it could be, we want to do it right away. I think that's just up to what you'd like to do in terms of policy.
At what point might you suggest we do it at the same time? I understand we won't tonight, but is there a case in which you would suggest we change it at the same time we rezone something?
Definitely if it's significant change. Let's just say they wanted to come in with a master plan community. We have that in another area. So let's just say that was here. Or they want to do something that was dramatically different than the general plan. Absolutely. However, also at the same time, there's no reason why, you could direct me to say, in the future, let's just add, if we're going to, even alter just a little bit, let's do the policy change first in terms of the same night, and then the rezone also at the same time. I don't have a problem with that. And I know Morgan is I've learned Morgan City kind of has done that in the past, but I definitely recommend it if it's a significant change. In this case, where the general plan was drawn with crayons, and zoning, of course, is very specific, and it's more with, pencils and pens, I would say. Gary, do you have anything in addition you'd like to add to that?
I think
General plan. Those generally where things are supposed to go, that's the reason it's called the general plan. And, and it doesn't, until you get the finer pencil defining where the lines are. You know, that is really up to the planning commission and city council to define where that is. You'll notice, here, there's no line, property line or, zoning line that actually defines where that thing comes down the center, where that shaded area comes down the center. And so that leaves you the flexibility to be able to take a look at plans as they come in and to be able to adjust for the zoning. When you actually, zoning is the fine print, and this is, the general plan is just a general idea of where things ought to go, so. But, also, like Jake and the mayor, Ray pointed out, if it is a large change, you really ought to bring it through as a change in the general plan and the zoning at the same time. You can do both of them at the same time. And Jake and I've talked back and forth. This is not that large of a change that would warrant that. And so, unless you dictate it, you should make that recommendation.
Yeah, happy to do it. I do want to call your attention that the area on the south, these blue dots, this is the sensitive lands area, according to our sensitive lands ordinance and maps. There's no significant issue for a rezone. However, if they do come back with a subdivision, assuming it was approved, if they came back with a subdivision, then the sensitive lands would apply and there would be additional requirements.
So sensitive lands means what?
In this case, floodplains.
Okay,
Along the creek.
floodplain. That's what I thought.
Floodplain,
Okay,
yep.
right along the creek.
In Morgan, typically it's either a floodplain from the two East Canyon Creek or Weaver River, or the other item is slopes greater than 15%.
Jake, setting aside the modification of
Yeah.
the general plan for a minute, I just want to make sure I understand the terminology correctly. Would the R110 be considered medium density and the R112 low density?
Yes.
Or, okay,
Yeah, it matches our math.
okay.
She moves that question further to clarify that for us. R110, and correct me if I'm not correct, means that the lot minimum size is 10,000 square feet.
Correct.
Be 10,000 or bigger. And then the R112 means minimum lot size is 12,000 square feet or larger. Is that?
Correct.
We understand. Okay.
Correct.
And then did you use the word net? When you take the roads out, the gross number would be smaller than that. Is that correct? Or am I got that thinking backwards?
So,
I was confused on your.
Because
your
yeah, that
net-
won't affect the
your
lot
net
size.
number.
no, it has nothing to do with the lot size.
Just a number per acre, number per lot.
Yeah,
number per
it
development.
helps in terms of how do we want to interpret the general plan?
Mhm.
But it has nothing to do with the lot size. Just helps us. What I like about the general, some cities actually, their general plan land use looks exactly like their zoning map. Because it really happens all the time. And you know, they say we want, you know, R10 here and all that. In our case, we have more general categories. There's a number of zones that can fit in the LDR bucket. There's a number of zones that can fit in the MDR bucket. And it gives the city flexibility as things evolve.
It would be helpful for me in the future to clarify in the notes which bucket these
Yes.
fit into, just because, you know, we're using one term in one case and another term in another case. So,
And that is something we discussed a couple months ago, was kind of a user guide to the general plan.
Yeah.
Kind of a Cliff Notes version, an interpretation kind of.
just a key to refer to.
Yeah,
or
yeah, just
anything.
a supplementary, non-adopted kind of, here's how we interpret things. Okay, well, I'm gonna move on here. This is the sensitive lands as mentioned. So, and there's also the well protection area that's here in orange. And so that area, again, at a subdivision level, that's when there would be additional engineering requirements. Making sure that this water, you know, the rainwater goes into the ground and can be used for wells. This is the transportation plan from the general plan. And these yellow dots are what was drawn in. So you see at least the different connections acquired. And in this case, it shows a future connection coming here in the south, if you see that area. And then certainly also going over, what is that, Webster? And then 400 West. So what helps us, one is to know that the city is planning and think about transportation connections to this area. But also, if a subdivision application came in, we could require that these street connections happen or stubs in the case of the Webster and the other one down on the south.
While you're on that, I understand it's just conceptual. On the bottom where you were pointing just a minute ago,
Yeah,
I understand that one, but if you go straight up, that one, no, I'm sorry, go back down where you were, the other direction.
this one?
That one dot right, go up to your right.
Oh,
One
that?
dot right there shouldn't be there.
Yeah.
There's no way that road's gonna go in.
That makes sense because that goes through lots. These dotted lines,
Or just a guess and preliminary, I understand. that.
yeah, those were actually on the adopted general plan.
Oh,
So,
okay.
but thank you. We'll have to fix that when we update it, the next time we update it.
There's the cost. Thank you.
But. Okay, this is the park map. I just bring it up as the general plan, does show that in this part of the city, there is a park deficiency. And we have the Fox Point Park, which is quite a distance, and then also Riverside Park. So, we're hoping that the applicant would work with the city. It's not a requirement, but we'd like for them to work with the city on a park if the project does go forward. And then also the general plan recreation map does call for a trail on Canyon Creek. Trails cannot be required like streets. However, we can encourage them to work with the city and discuss options. Here's some pictures. This is the Rupp subdivision under construction just a couple of weeks ago. See it there on the north. Oh, this one is looking south. So I'll fix that. There's the Canyon Creek right there. Also looking southwest. This is that connection that we're talking about, the main one there. And then also another Scotts Drive. Okay. 525. The other one, the Scotts one that we're talking about, was down here. And then another view looking north. From farther back. So, any questions? We'll go over this again in the main session and we can dive into the discussion, but the purpose of this is just to give you a chance to
I have one
make sure you
question.
understand and clarify.
Right now, that 275 north dead ends. In other words, there's only one way in and it dead ends at the far side.
We get to the transportation one. Oh,
At Pheasant Run subdivision,
Yes, right here.
at 275 north, it's dead ends right now. And with this property
Which one is that?
being proposed here,
Oh, right here.
is that going to go on down to the Island Road, or is it going to connect into this property, do you know?
Uh,
Huh?
Yes and yes. Answer yes and yes.
Yeah.
it can connect and I think, and we can ask for that at the subdivision level.
That right of way was dedicated to a full-fledged right of way.
Oh, yeah.
At the time that subdivision went in, but right now there's a gate and you can't use it.
You're saying this right away right here is already dedicated, so the city can use that.
Okay.
So it's dedicated for the developers. Yeah, when the next already developed, that was slated to go in.
And it's the same landowner. Yeah. Okay.
So they haven't decided on that, cause it seems like the last time, we talked about that, that it was kind of still up in the air a little bit on how that was going to tie in. Is it gonna be done with this new subdivision? Is that gonna,
Well, I would say potentially if the subdivision moves forward, tonight we're just voting on the rezone. And then potentially if approved, then they could come back with that application. I don't know who would be responsible to pay for building that, if that would go on to the subdivision or the city could negotiate to share in the cost of it.
We'd probably have to jump into the details of that, but just to let you know, the purchaser, it's owned by who's doing the rezone. So they already purchased it, so.
Oh, the right of way?
It's no longer part of the Hardy,
Okay,
owner.
so
Yeah.
that is an advantage that property is owned by the applicant.
As Wes mentioned, that road enters the property of the person that personally owned the road on the first piece of property.
Right.
The new developer bought all the Harding property plus that right of way.
oh, okay.
Yeah, okay. Okay, anything else before we move on to the
Got
training?
one Question on the upper end of Pheasant Run or that, what do they call it, 100-year pond? Does that change with this or
The pond,
where that road, where it dead ends now?
Is that right in
We're
here?
talking about.
That will change into building lots or?
No.
that pond will stay there.
No,
That pond has to stay.
That pond has.
Okay.
Yeah, the pond stays there.
Yeah, if it's serving as a stormwater basin, that definitely
The
won't go away.
one that potentially will go away is the one down on, the road that goes through. Now is a turn.
All that one lot?
Uh-huh.
And so does that right of way connect to Island Road, 300 West?
Yes.
Okay.
So currently in the Pheasant Run subdivision, there's one dedicated lot that's a turnaround on 525.
Yep.
Once development occurs, that will no longer be a dedicated turnaround for fire trucks and stuff. But the detention pond is a permanent structure.
Okay.
Is that right here? Is that what you're talking about, Teresa?
Yeah, so it's going down, it's on the west or north side, I don't know.
Yes.
Yeah, right there.
Yeah, that will
Oh.
turn into a building lot. Right now, it's restricted. to not be built.
Okay.
It's the bottom side of your ship.
Oh,
Yeah,
oh, it's
bottom
Is
the-
that one?
it's that one. Yeah.
Right
okay.
there.
Lot 13 in that Pheasant Run subdivision. It's restricted right now, but that
Right.
restriction would be removed.
Right.
And there are commitments in a settlement agreement with Pheasant Run regarding access to 300 that would probably need to be looked at because there are commitments the city has made to make sure that that is a right of way
Okay.
connecting up to 300.
Yeah.
But that's when we get to the subdivision, we're not there
What
yet.
was that, Gary? Which road?
That's the road that connects, that exists, that the Turners, or that Harding owned and was purchased by the
That's
developer.
it.
There is a settlement agreement between the Turners and the city and other property owners that talk about that road and its development and the fact that they need continued access off of it. So we just need to be aware that that exists. And I was just letting Jake know that when the subdivision comes before you, we'll have to address that.
Right, plus the other right of way too.
Yep. Yeah.
Nate, from the middle of your line there, Nate, draw a line straight down along that, through the back of those people's properties. Right there, yep. No, right there, yep.
Like that?
Right there. There's gonna be a heavy discussion on that concept too.
Can you expound?
Probably,
Currently,
yeah.
there's a agricultural right of way down through the
Oh, yeah.
people's properties. And it doesn't go to that property line. At some point in this discussion with subdivision, that will be brought up, I'm sure will be part of the discussion, where those people would then obtain their property back to the property line. At what point does that agricultural right of way go away? That'll be a discussion for later, not for,
Yeah.
now, for later.
Yeah, okay. That's good to know. Thank you. Okay, any additional comments? Okay, Gary, you were gonna go over some training.
Sure. You look so excited when that comes up. Nothing like listening to a lawyer for
Training, come
what,
on,
20
it's the
minutes?
best. Wes would have come later if he
Just
would have
not
done that.
entertaining. I've thought of different ways of doing it. Do you dance to it? Do you sing to it? How do you do that? How do you make it look good? Or how do you make it look fun? So, yeah, yeah, need more than that. There you go. We'll pass out the energy drinks right about now. I just got a note, just asking if I talk about two things, and one would be public hearings, and maybe the distinction between public hearings and public meetings, because Planning Commission actually deals with both. And then the second thing is ex parte communications. You know, when I first went to law school, I had a professor that used to really believe that lawyers needed to learn Latin. And it was horrible. It was the worst class I've ever taken because I didn't understand a word he was saying, and I didn't get a very good grade in that class. But one day I remember I came to him and I said, you know, why do we need this stuff? I mean, it's you know, in the whole perspective of the law, why do we need this stuff? And then I asked him, isn't my concern valid? And he looked at me and he goes, he made some statement that said in Latin, I'm sorry, I'm not concerned, and the law doesn't concern itself with little things like your concerns. And I thought after that, I thought, you know, maybe maybe there's something to that, because you can actually say things to people that they don't understand, and they're all sitting there going, yeah, you're very intelligent. We appreciate it. You know what you're talking about. And so what is ex parte communications? Let's start with that. Ex parte communications are communications. Does anybody know what that means by any chance? Have any of you been in a courtroom where the judge says, no ex parte communications? And okay, I don't expect you to.
Ex parte?
Ex parte.
Yeah, conversations where every party is not involved.
Very good, Aaron. That's exactly what it is.
Well, I did take Latin.
I was gonna say. You and I need to talk after in Latin. But anyway, the ex parte, yeah, where all the parties aren't there. And one of the things that differentiates the Planning Commission from a city council is I could go all day long and tell city councils, you don't talk to people outside of the council meeting because it's just going to get you into trouble. And it often does, because they'll go to a meeting where there are folks there and the mayor will be over there shaking his head, you know, like this. And then all of a sudden, when they come to the meeting, they'll say, well, and the mayor agreed to everything I said because he shook his head at everything I said. Gets you into trouble, right? It does, ex parte. So attending those meetings outside of the group on a decision that you're having to make can get you into trouble. But planning commissions, on the other hand, are absolutely discouraged from ever participating in ex parte communications, whereas city councils, they were elected to listen to the people. That's the difference between a planning commission and a city council. So if the city council person decides that over in the marketplace, he wants to listen to somebody's objection over an application, he's allowed to do that. They're allowed to do that. Planning commissioners, the only course for you really is to say, you know, this is something I have to make a decision on. It'd be great for the rest of the planning commission to hear your concerns. So let's, you know, come to the meeting. We'll give you an opportunity to share your concerns. On the city council side, I advise the city council, if they have had that communication to the market, to come back in and to talk to the city council about the fact that I did have an opportunity to talk to some of the neighbors in the market. And here's what we talked about. disclosing to the entire council exactly what was talked about. But planning commission, general rule of thumb, if I could make it more of a rule, an absolute rule, I would say no ex parte communications with either the developer or the members of the community that are concerned, because you're going to hear it all anyway. You are the only body that will hear a public hearing on a zone change, for example, because the city council no longer, they took that away. The state of Utah took city councils having a hearing on a zone change. You're only required to have one. You could have two if you wanted to, one at your level and one at the city council level, but you're making a recommendation to the council after a public hearing on your level. And that's the way it is in Morgan right now. There's not, they don't get two shots. And the main reason for that is, what do you hear at the city council meeting that you didn't hear at your level? Almost same thing over and over again, right? And if you do hear new information, and we did have one application, you might remember, where they stood up and they gave a bunch of new information at the city council level. What should the city council do with that? Do you think if they, all of a sudden you get a whole bunch of new information on access or on where the wetlands are or something new that your planning commission hasn't heard about, you could send it back to your planning commission if it was big enough and important enough to be able to discuss. So the city council really doesn't need to listen to new information. They can send it back to you. If it's just little things, they can listen to it. Ultimately, the city council can make whatever decision it wants, because the standard for making a decision for you, as you recommend it to the council, and then for the council to make a final decision, is a rational basis. And that rational basis, 90% of the time, is it conforms to the city's master plan. That's usually your rational basis. And as you make your motion, you say, I move to approve this application, or I move to disapprove this application. You generally will state that your reasons for doing that, your rational basis for doing that. And you'll either do that after the second when you have discussion on the motion, or you'll do it at the time the person is making the motion. They can say, I make a motion to approve this rezone application because it conforms with the general plan and because whatever other reasons that you've got proper access, the densities are good, whatever reasons you decide you want to do that. So that's ex parte communication, ixnay for the planning commission. That's not Latin. That just means absolutely not for the planning commission. And for the city council, I'd strongly advise against it. And I've told them that, and they're great about it. The city council and mayor have been great about that. Although they're going to get an earful no matter where they go. Church on Sunday, back of the room, just as they're about to leave or go to Sunday school or whatever they're going to, they're going to get an earful about the subdivision that's coming in at such and such a location, or zoning that comes in. It's just a practical. And so are you. And so the best thing to do is just parry it off, yes.
Yeah, I really appreciate this, because in my old neighborhood over there, where that new subdivision is proposed to go in above them, they've invited me to come and have a discussion about what my opinion about that. And I said, I don't want to be involved in that. That's the right answer, right?
Yes, that's perfect. That is perfect.
Okay,
Yeah, you can.
because,
Parry it off, say,
they know I'm on the planning commission. They want me to be on their side.
Oh, yes.
And
Yeah.
I'm going, hey, I don't want to touch this. So that's what I should do.
That's absolutely what you should do. It's called lobbying. It's
Yeah.
kind of like, it's parrying it off is what
Yeah.
you're parrying the lobbyists off is what you're doing. I remember we took a bunch of scouts down the Snake River one time, and my guys were just little short guys. And this great big group of Tongan scouts came down the river the other direction, and they were going to dump them off the raft, I remember. And I could see this happening. I was going to pick up 15 kids out of the river, and I just yelled to them. I said, when they come at you, don't stand there like a wall. Stand there like a blade of grass and just let them go. And so these little scouts are all, what do you mean let them go? When they come at you, just move and shove them. And it was interesting, you see all these big tongans going all the way over the boat and parrying off into the river. And I thought, there's a lesson to this. There's a way to parry. You're not the wall. You don't have to sit there and go to the meetings and listen. That's not your responsibility. In fact, it's just the opposite. Your responsibility is to say, you know what, you need to come to the planning commission where this entire body can hear about it. Next one, public meetings and public hearings. There's a thing called public clamor. You've heard it. We've used it a dozen times because it originated in Davis County, in a Davis County case, where the court said, you know what, the public said a lot of stuff in that meeting, but really none of it had any relevance to the application in front of you. So we're going to deem that public clamor are not valid reasons to base your whether it's an administrative decision or recommending a legislative decision. They're not real good reasons. What is public clamor? Generally, it is anything that doesn't have anything to do with the application you're talking about. It begins to become public clamor when, and this is a key item that I'm going to say probably over and over again over the years, and that is that if your meeting's out of control, your chair's got a problem because it's the chair that controls the meeting. So if you're starting to get people say things, same thing over and over and over again, it's the chair's opportunity. Then it becomes clamor. After the first time it's said, and the second time and the third time, and you're hearing the same arguments over and over again, it becomes clamor at that point. And essentially, it's almost like you're taking a vote. Okay, we had 15 people come up and say that it's going to kill children, you know, if we put the subdivision in. And so the chair is the one who should stop that. You know, regulating the amount of time that if you got a lot of people in the room, you're allowed to. You don't make it too short. You don't make it too long. Don't let them go on forever. But you can say, for example, we've limited the time to 3 minutes. We've asked you to consolidate and you've heard the chair say this before, right? Please consolidate your remarks so that everybody's, you know, if you got one spokesperson for all of you, please, we'll give that spokesperson additional time because he's talking for all of you. He or she's talking for all of you. But public clamor also, when they're becoming far afield or getting far afield, away from exactly what the application, like for example, a zone change is dealing specifically with, is there access? Is it consistent with the general plan? Is it time to make the change in the zoning? Those are the three things you're looking at really. And, you know, you can ask for more information, but that generally comes at the subdivision level. And so if people are getting into, well, how many homes are they going to have across from mine? And is the home across from mine going to be higher? Is it going to block my view of the M on the side of the mountain? Or, you know, exactly. Those are things that the chair can say, you know, those are outside the scope of what we're determining here tonight. We're determining here tonight a zone change. And the zone change, we look at whether or not it's consistent with the general plan. We'll get into all the details, and they may not be able to get the densities they want, depending on what they bring into us after this point. But so the chair is the one that regulates that. And the public hearing should be organized, and you let people speak. Public meeting is what you have when you have a subdivision approval or administrative determination. And there's a distinction. In a public meeting, you can actually ask for comments, but you don't have to take comments. And so in a subdivision application, you don't have to take comments in a subdivision application because it's a public meeting and all you're required to do is apply the law to this set of facts that are coming in before you. We have these lots, we have the recommendation from the planner, we have the recommendation from the engineer. And if you feel that there's a reason to open it up to public comment, you could. You're allowed to do that. But you're not required to have a public hearing on every subdivision that is approved in the city. In fact, just the opposite. The legislature said, we don't think that there ought to be a public hearing on subdivision approvals. We really don't, because all you're doing is applying the facts to the law, the subdivision laws. And so that's the distinction between public meeting and public hearing. Are there any questions, or have I really put you to sleep tonight?
Define that
Okay,
different public hearing and public meeting.
so a public hearing is required by law. You have to advertise it a certain amount of time before the date of the public hearing. And you have to indicate that individuals will be given the opportunity to speak. And that's where you're required to allow individuals to speak. Then you close the public hearing. You're going to do that tonight. Public hearing, there'll be a public hearing tonight. And you'll open the public hearing and you'll listen to comments and you'll then close the public hearing, have a discussion with the planning commission. And at that time, there may be people who are still yelling things from the audience. Once the public hearing's closed, unless you reopen the public hearing for a good reason, it's back in your hands. It's back in your hands. So that's the public hearing. Public meeting it just means you have to make your decision regarding subdivision approval or conditional use approval or any of your administrative decisions that you make. You have to do it in public. You have to do it with the public sitting there. But it does not mean that you have to listen to anything that the public has to say. You can if you wish to. If the planning commission says, I'd really like to hear more about the way that stream runs through there and how that trail might be developed. Developer, do you want to take a few minutes? We'll reopen the public hearing and developer can take a few minutes, or we have a few questions for the guy that raised the issue. You can actually do that if you want to as a planning commission.
So should the chair, when there's a public meeting, should the chair mention that the comments are not allowed?
Absolutely. Yeah. Just if you're doing it, making an administrative determination, which is a subdivision approval, then it's appropriate for the chair to say, if you want to, and you have Jake here or you have me here, you can say, let's have them explain the significance of a public hearing and what the part of a public hearing is in making our decision tonight. And we'd be glad to explain it because sometimes it helps, to have somebody just explain it. But essentially the chair can ask for that explanation. And that really helps. It really helps up front because people know and don't have expectations that they're going to be able to sit here all night and continue to make comments. So is it making sense or? Okay. So the two separate things, whenever you have a legislative decision and you're making a recommendation on it, there will always be a public hearing involved before the planning commission, before you send it on to the council. You have the option of leaving the public hearing open if you want more information. You can leave the public meeting open until you can even deliberate during the public hearing if you wanted to. It's always better, in my opinion, to close the public hearing so that it's just limited to your back and forth, rather than leaving it open so the public can get up again and again and again. But that's entirely up to you how you arrange that. So if Aaron and I go speak Latin after the meeting and the rest of you don't understand what we're talking about, then I've succeeded tonight.
Is there a standard on the hearing? Is there a standard time limit?
You know what? There's not, but I have used in most cities 3 minutes.
Okay.
If it's a person who's speaking for a lot of people, you might let them have a little more of a free rein. They're speaking for everybody in this audience. I'd give them probably as much time as they needed to get their arguments because they're usually organized. They have all their points and you let them go ahead and do it. So does that make sense or? Okay. All right. And remember Perry, whenever you're out there and they want to talk about a Perry. Okay. Anyway, thank you very much. I think we're going to get you out on time. Yep.
Gary, you ready? Okay. We'd like to welcome everybody tonight to my planning commission meeting. Let's see. We want to excuse Nate, Lance, and Justin. And I'm reading my notes here, guys, so you just have to bear with me. Has anybody had time to review the minutes from June 18th? Yeah. Yeah.
Sure, I'll make a motion that we approve the minutes from June 18th.
I'll second that.
Okay, we have a motion to approve the minutes and a second. All in favor?
Aye. Jason got aye too.
And, oh, Jason. Hi, Jason.
All in favor.
All in favor? Okay. All right, let's get going. Let's see. Item 1 is we're gonna open it.
Just read this and turn over to Jake to explain.
Okay. All right, we're gonna turn the time over to Jake to talk about what's going on tonight.
Thank you, Chair. So I'm going to go ahead and we'll proceed with the first item on the agenda, which is we have a rezone request for some properties on the southwest part of town. And I'll provide a little background report based on the report that was delivered to the Planning Commission. And during the report and after, you can ask questions. And then when you're ready, you can open the public hearing and see if there's any comments from the public. You can also close the public hearing and then ask the applicant questions as well after that, if you'd like. Is that how you'd like to proceed?
We have a motion to, are you ready to open the public?
I'm going to give a background.
Oh, okay.
Okay. And I'm going to do a screen share here, and this will share my report. Okay. I do want to clarify there's a couple items in this report that have been updated since you received the packet and the Planning Commission report, and I'll point those out, and this will be part of the public record, and Teresa will add it to the agenda. So these are the properties that are being requested to be rezoned. I'm not going to read them, but I'll just highlight them here. Three properties, parcels are part of the R110 request. And then also, additionally, we have 2 that are part of the R12 and then part of, it splits down the middle. So the 1341 and the 1333 split, half go to the part of them go to the north and part go to the south in the request. It's approximately 77 acres in the city. The current use is agriculture. It's being farmed, and it is within the city boundary. I'm going to come back to my recommendations at the end. I'm going to go through the maps here and provide a little bit of background information on it. This is the entire property being requested for rezone in the southwest part of town. So this area in the north is being requested from agriculture to R110, meaning a minimum of 10,000 square foot lots. And a correction here, this is provided by the applicant today. And also he double checked it with the city engineer. The red line is the correct R110 boundary as proposed. However, it does match the original property description that was included in the applicant, which is more in the application, which is more important. And so on the north, we have 350 West, also 400 West, and then the additional street connection. What was that street again?
525.
Oh, 525, but this one right here on the right side. Oh, okay, there's no address there, but that does provide a connection opportunity out to Island Road. Then the parcels being requested for R112 are on the southwest. And also again, here's that red line approximately. So these ones are being requested at a minimum of 12,000 square foot lots, the R112 zoning. And the Canyon Creek on the southwest is the city boundary, and also this area is up against it. This map shows the existing zoning of Morgan City. The current zoning for the property is agriculture. To the north, we have two areas that are R112. We also have R18 in this large kind of tan yellow area. And just for reference, R18 is effectively R110 in terms of if any new development were to occur, that's the standards they would have to follow. And then to the east here, we have R110 in this zoning. And then also to the north, we have R120 in this yellow orange area. And then also existing ag to the west. And then the southwest is unincorporated Morgan County. So that's the surrounding zoning. And certainly there's a mixture of surrounding zones. The proposed zones are not significantly out of line with the current zoning and also with the zoning that's occurred over the last 5 years in terms of the more recent zones, particularly the R112. So this is the map that was provided with the application. And then the updated one, which matches the legal description. This is it right here, R110 on the north, R112 on the south. As part of a rezone, it's important to consider the general plan. General plan was adopted this year in 2024. And in the general plan, this kind of sandy color area is called out as medium density residential, and then the lighter yellow as low density residential. And the R110 is compatible with the medium density, and the R112 is compatible. Again, the word compatible, it is up to your discretion to make that decision or recommendation. And then area in blue is sensitive lands area in the floodplain. That shows up on another map. Included in the packet is the description from the general plan. The LDR as 2 to 3 units per acre, that's gross acreage. So also including right-of-ways and other non-buildable areas. And then also the medium density is 3 to 5 units per acre with additional, that's also gross density for that. And within these description, it talks about what kind of development. And the LDR, significantly single family, and then in the MDR, single family, but also compatible with smaller lots and potentially multifamily. So the question, how does it line up with the general plan? This map shows that. I'm going to go ahead to the adjusted general plan based on the information that was recently provided. So the line in purple is closer to the difference between the area being requested as MDR. So from the purple line going north, that's the area requested as MDR. And then from the purple line going south, that's the area requested as LDR. And this is from our general plan. This shows the areas according to the sensitive lands map. We have a well area, a drinking water source protection here, zone 2. In terms of there's current development within that, and in terms of a rezone, there's no significant change. However, if there were a subdivision proposed or some kind of, change to the built environment, then there would be specific restrictions and things that apply to that to keep the water protected in terms of the water percolating into the ground for wells. And then on the south, we have the floodplain area identified here in blue. So this is the transportation map in the general plan. And it does show some proposed street connections, the dotted orange lines. And they don't necessarily change a rezone. However, if there is a proposed development, then Planning Commission as well as staff and city engineer would work with the applicant to be compatible with the general plan in terms of getting proper street connections. Kind of shows you, and just like land use and zoning, transportation also does look at ways to adapting and implementing these basic maps. And I do want to call out, as mentioned earlier by Ray, that there is one error here. And just that, of course, this connection here would not work. However, the other ones may work. Just kind of want to bring that up. But that would not affect a rezone. This is the general plan park study map. It does show in this area there's no parks in Morgan City, a park deficiency. And so the general plan does encourage any potential development and developers and landowners to work with the city and try to get park space in this part of the city. This is the recreation map from the general plan. And you'll notice there is a proposed trail on East Canyon Creek, and it's not required, but it is recommended that the city work with landowners and developers and others to create trails throughout the city, and in particular, a cohesive trail plan where you can get around on trails. And this area has been identified as an opportunity for that. And so here is a picture of the property looking north. Subdivision currently under construction there, and the property boundary is about right here, coming down. And then looking south, so you see that coming down and over, so that gives you an idea of where that, so agriculture land with the East Canyon Creek there on the south. Fairly flat, and there are some canals that go through it. Looking southwest, this is one of the streets that, if there was a development, would need to be connected to. Gives you a bird's eye view there. And then also, again, looking north from a little bit further south. Also in the report was some detailed review. General plan, does match up, generally, use the term generally, it's not exactly, but it is compatible with the general plan, the proposed rezone. Um, and, and it also is compatible with the city's transportation maps and plans. And there may be a development agreement that would, if the project moves forward, development agreement would be decided by the city council. And then as mentioned, the property is in the sensitive lands area. And then also included in the application was the legal description of the property. And we did have the city engineer just today double check that, and it does line up sufficiently with the proposed rezone areas. And staff recommendations is that the proposed rezone is compatible with the general plan and both land use and transportation. There is a little bit of difference between the medium density residential and the low density residential. However, it's not significantly different. And the planning commission has a number of options. You could recommend that if you agree to, if you recommend the rezone, we could come back later and update the general plan and future land use. We could also update it with if there's other items that need to be addressed. Also, you could you could vote no on the project and still update the general plan if you wanted. It wouldn't make sense, but you could. And of course, you could vote no on it as well. Just presenting the options there. Any questions on the report? As I mentioned, it's not exactly lining up, but the general plan is advisory, non-binding, and it is at a higher level where zoning is a little bit more detailed. Any questions on the report from the Planning Commission? So I do make some comments there that we encourage the landowners, developers to work with the city on potential trail projects and parks. We definitely need it for this part of the city if the project were to move forward.
Is this, when we redid the general plan, is this kind of consistent with the outskirts of the city? Is this the direction that?
I would say, yes, it's compatible. I mean, when you do a general plan, you don't always have a specific exact vision for areas. However, compatible, transition from, two densities of neighborhoods as you move out, that is compatible. Single family in the area, definitely it was discussed that this part of the town could transition from agriculture to single family, and also that street connections will be needed in this area.
So it's my understanding that the proposed area is already within the city. It
Correct,
doesn't have to be annexed.
correct.
Okay.
And it's been that way for quite a while. I don't know how long, but a long time. Since we didn't update the annexation for more than 20 years, right? So definitely a long time. That's all that I have, unless you have any specific. I don't necessarily want to go over everything that's in the report.
Okay, we welcome everybody. We'd like to open a public hearing.
I move we open public hearing.
I second.
So we have open and a second. Is there any
discussion.
Any discussion on what Jake's had to say? No. Can we get a vote on opening? Everybody in favor? Yeah, aye. Jay, okay. So we have unanimous on this. We'll move into the public hearing.
We'll open for them to come state the name.
Oh.
Maybe wishing to see anything, they may state the name of the podium.
Okay, anybody that wants to, talk on this, just step to the mic and state your name so Teresa can get the information.
Ian George.
It's green, I just.
Thank you.
Hi, my name's Ian George. I live over in the Pheasant Run subdivision, and this property that is being proposed is adjacent to us. And none of my neighbors have received notification about this public hearing. So my first question to the group is, what is the requirement for public notification of a public hearing to rezone property? Because as far as I know, no one received anything. So if that's a requirement to have it rezoned, I propose you delay making a decision until proper notifications have been sent out. Right?
Gary, would you like to address that?
So let's go ahead and take the questions and comments. And then at the conclusion of the public hearing, we'll see if we can address some of them. If not.
Okay.
And this is a public hearing, so we hear your input.
Okay, yeah, my input too is, I have concerns about all the ditches. They're not quite canals, but ditches and irrigation works back there. Will those stay in place? What will the easements be for those? Will it just be pressurized secondary water? And for the size of acreage back there, where it's roughly 77 acres and some change, you know, if you put in 2 to 3 homes, you're talking 200 to 300 homes back there. So you could have potentially 1,200 new residents in Morgan. So, and if you have 1,200 new residents and half of them are school age, are the schools going to be able to accommodate all that with class sizes already up there? So. Sure you know what you're getting in for.
Thank you. Anybody else have anything?
I don't have any participants online.
Okay. Commissioners, anything?
If there's nobody else, you can close public hearing if you want.
Yeah. We need a motion to close the public hearing.
I'll make a motion that we close the public hearing.
Okay, we have a motion from Mark. Can we
I
get a
will
second? And a second from Aaron. All in favor of closing the public hearing, say aye. Aye. Okay, public hearing is closed.
If you want to hear from the applicant, you could also do that as well.
Okay. We'll hear from the applicants on this now.
Or do you want to answer that question first?
Huh?
Or do you want to answer the?
Gary was gonna answer that at the end, right?
Yeah, so the public hearing has been closed. Exactly right, Mr. Chair. And now would be a good time to, if you wanted to respond to the questions, you could have staff respond or the applicant can respond to some of the issues. The notice issue would probably be best to be responded by either Teresa or Jake, because there are specific requirements in state code of how these are noticed. And so we have to go through those, jump through those hoops. And then ditches and irrigation, and then I'll address schools if that's okay, but ditches and irrigation, maybe the developer can address that, or Jake could address that.
Teresa, you want to address the?
Yeah, yes, if you could address the noticing part since you handled it.
All right, as per state law and on our ordinances, we follow the state requirements as far as public hearing notification. A public hearing notification, once an applicant comes in, is to be published within 10 business days of the public hearing. It's required to be notified on the city website as well as the public meeting notice website of the state. It's also required to be in, well, we go above and beyond and we put it in more than one public notice area. We actually do 4, which is the city. We take the bank, the post office, and the library. We don't do notifications to individuals around that. That's not a state requirement, and that's what we follow, and they wouldn't. And so that's part of our ordinance. And if you'd like to, I can surely send you the email of where it is. It's up to you though. Okay?
Thanks, Teresa.
On the ditches part, with this being a rezone, there's no proposed development. I mean, if there is a subdivision, which of course there is talk of one, then that would come in, next, if a rezone was approved. And then I think we should ask the landowner, developer, what they would do with the ditches. However, what I've always seen is that there's requirements to, if there's other people downstream from the ditch, users further down the lines, then there are agreements that require them to continue to get water. It may be piped, it may be channeled, it may be moved around, but I've always seen that there's requirements to carry that water through to those who are downstream of that water. However, it can happen in lots of different ways, piping and moving and rechanneling. And then Gary was going to talk about school district.
Sure. Developer want to address the ditches and how our current city ordinance requires that there won't be any open ditches, that they all have to be piped. And so wherever the water goes, it has to be, it has to be piped. That's, I think Jake made reference. Yeah, sure.
Go ahead, you want to step to the mic?
Thank you for entertaining my question. My follow-up question is will existing easements on other homes that have been burdened by this, what do they call it, the primary estate, there's a contested easement back there, or was for a long time. It's been settled now. But will that easement stay or will it go away? And the primary reason is for accessing ditches and head gates and such. So if it's all piped, does that 10-foot easement still exist?
Jake, do we know that yet?
Yeah, so that would be handled at a rezone. They're just looking at what you can do now versus what you can do in the future. If there is an application for a subdivision, then easements would be addressed to that. And if there's a need to continue to be able to access, if there's a utility need to be able to access water and utilities and things like that, then an easement typically continues. But again, that's at the next level. So if the project does continue, then certainly come to meetings and pay attention and provide your input.
And so the zoning phase is just simply to say, yes, this is a use that would be appropriate for this property. And the general plan actually indicates that in the future, yes, this ought to be residential. And so it would be up to the developer to come in and make an application, subdivision application. And a lot of the questions you're asking regarding the easements, which should be settled at that point. Schools, expressly in state law, schools are required to service no matter how many kids come into the jurisdiction. So if it requires an increase in general taxation for everybody to increase the schools, for example, when Mountain Green developed, a lot of that developed, they had to develop new schools. But as far as the Planning Commission considering that as an element that would determine their zoning. They're not allowed to do that under state law. So the schools essentially have to make a determination of how they're going to handle new populations if they come in, but it's not an item that these guys can address. So.
Yeah, thank you. Ben Russell. Hi, Teresa. Is there any questions right off the bat? I mean, I think we've kind of went through, Jake has done an excellent job kind of describing what our application is. Again, currently it's two different landowners. Have kind of collaborated in an effort to make this more of a cohesive type of development so it can be master planned, and many of the things that have been brought up and mentioned by Jake and others tonight we feel like can be addressed better in the way that we're going about it, because it's just not in isolated little pockets. It's looking at a larger space there and kind of master planning as one. So that's our objective. But again, with tonight, just looking at it as the rezone, is there any questions related to that haven't been addressed that we could address?
I have one. I know that backside of those properties where that easement was for years, is that? I haven't kept up on it. Is that resolved?
Next to Pheasant Run,
Yeah.
my understanding is it's resolved, yes. Mhm.
Good.
Yeah.
Any questions?
I don't have any questions really in the rezone. There's a lot of stuff will come up later.
Oh, yeah.
Yeah, a lot of stuff still be worked out, and I appreciate the staff. They'll work all those kinds of things
Yeah.
out. So there's, lots of questions, but none of them necessarily apply to the rezone.
Yeah. The first step is typically that water advisory board meeting, and so that was an excellent question, but that's always kind of handled there, and yep. So, okay, if there's no other questions, then I'll get out of your way.
Mr. Chair, can I just make a comment that just explaining for Mr. George? The next step would be the planning commission would recommend either approval, denial, or adjustment to the city council. And so it will go to the city council for their approval next. Then comes the applications for subdivision, and that's where a lot of these details that you're asking about will be hammered out, should be hammered out. Thank you. Thanks, Mr. Chair.
So, anybody got anything else? We will, I'll ask for a motion to, what's the proper wording? Not accept.
Recommend approval
Recommend.
or denial or whatever you're.
Recommend the city council, whatever the council wants to.
Okay, recommend the city council, to move forward, with the rezoning of these properties.
Okay.
Good vote.
As stated in the application or the report, I think you just want to tie the parcels, the parcels identified in the report.
Oh, okay, so we have,
You ready?
sorry,
Maybe.
we have, the R110 zone 04-180-001-2-1-1 parcel. And of 00-004-1341. And let's see, the R12 rezone request of 004-1358 and 004-1366, 004-1341 and 004-1333 tied together for the rezoning.
You're asking for a motion
Yeah.
on that.
Okay, so you need a motion.
Get one right here.
I move that we recommend approval of the application to rezone as is to the city council.
We want to recommend or. move
Make a
on?
motion.
Make a motion to recommend. That's the correct
Okay.
motion.
Okay, so we have a motion to move this on to the city council. Do I have a second? Ray, you got a second? We get a vote, all in favor?
Do a roll call.
Okay, roll call.
Roll call.
We've got somebody online too.
Start the end.
Huh?
Aaron?
Aaron,
Aye.
Ray?
Aye.
Mark?
Aye.
Jason?
Aye.
Aye.
Great.
Unanimous,
Wes?
and Wes? Aye. It's unanimous.
Okay, next slide. Turn it over to Jake to discuss it.
What is it?
Just turn it over to Jake to discuss item 2.
Okay, we'll move this on to Jake for item 2.
Okay, thank you. Thank you for coming in. Have a good night. So I'm going to move forward with our discussion on subdivision ordinance. Tonight, I just want to go through a few items to discuss in the subdivision ordinance change. This isn't going to be a complete presentation of the subdivision ordinance as recommended. There's a number of items to kind of work through to ask the planning commission how you would like the subdivision ordinance to end up. And on this, I recommend you pay attention closely. The city subdivision ordinance is 49 pages approximately. It's something that's been messed with and added to and twisted and over decades. And so maybe this is a good time to simplify it. But again, it's up to you. But this will be your ordinance because the planning commission will actually do the approvals on the subdivision and it won't go to the city council. That's the state law. So that's why I'm saying this.
Yeah.
No public hearing and no city council. There can be a public meeting, but we don't have to advertise and take public input. You can choose to take public input, but it wouldn't be a public hearing. And that is the recommendation from legal counsel, both Gary and other attorneys, is that you have a public meeting, you review it, you can take input if you'd want, but you don't advertise it as a public hearing.
Because land use, subdivision isn't in the land use. Difference.
Yeah, it's in its own ordinance, but it'll also be administrative, meaning like tonight, the rezone is a legislative, meaning planning commission makes a recommendation and then the elected body will make that decision on the rezone when it goes to them. Ray, did you have something?
So just clarify, so this is you're just gonna highlight some things tonight.
Yes,
Okay.
yeah, there's some
Would-
things to work
For
through.
question for down the road, would you
Yes.
like us to dig into it and come back with some items? Or you just want to wait for you to bring us other drafts? What would you prefer?
Please do. Yes, yeah, I would definitely recommend.
I guess I don't know if the chair wants to give an assignment, the plan commission to dig into it and bring back recommendations, if you want that done. Jim.
Yes, I actually, that would be really good, that the planning commission review it. If you could email your question or comments over the next 2 weeks, then they could be addressed in our September meeting.
Email them to who?
To Teresa or to me. We'll share them. Okay. And going over the purpose, the first section, I didn't see any significant items. However, I did see this. I like this idea of adding something about, let me turn this off. Okay. Turn off suggestions. Okay. This idea of also in our purpose, to provide a well-connected street network system. In here, we talk about homes and land uses and utilities and all these things. And the one thing I saw that it was missing is the general purpose of the subdivision should also provide connected streets. And in Morgan, you have some of both. You have some areas where you have really good street connectivity, and then you have other areas, particularly Island Road or some of that if there was a catastrophe or way to get in and out, then it'd be difficult to access. But also, people just walk less and bike less and drive more, when you don't have a good street system. It's also very difficult to plow the streets, trash, recycle. Well, you don't do recycle, but trash and everything else. So I added that. In here, we have a definition for alley. I just added a clarifier that the MRO has its additional alley cross section that only applies to the mixed residential ordinance. These are just a few simple, specific things. We'll get to a big discussion item here in a minute.
They don't have this. Are you gonna, once we go through this, you'll send it and they can use that?
Yes,
Or the reviews you already have?
I'll send you just a Word document with this, and then you can add your comments on.
Exactly what you're covering right now.
Yes. And I'll probably add a few things to it. Okay. Again, these are all definitions, fairly standard. I haven't seen any significant changes on this, but I'm also gonna be getting additional help from Gary on this. Okay. So we do have this definition here that the open space shall be open to the sky. I thought that was interesting. Does that mean you can't have trees? And so that was something I thought, okay, maybe let's just clarify that. And another thing, is this even necessary in the subdivision ordinance? I think having a definition is good, but defining what open space is. Okay, here's the first big change we have here is there's a lot on the sketch plan. The current subdivision ordinance requires 4 steps. A sketch plan, which is actually brought to you, reviewed by staff and brought to you. And then a preliminary plat, which is the planning commission reviewing and approving or not the preliminary plat. And then the final plat has 2 steps in it. And essentially, by law, the sketch plan has to go away as a requirement. It can be optional. And I'm suggesting we keep it as an optional. It's optional to the developer. If they want to bring in a concept plan and talk with staff, they can. It's actually a good thing. It helps everyone. But it's not a requirement per state law. So that's a big change in that. So I'm working on language on altering this that the sketch plan is optional. I also added in that it's optional by staff. If someone's coming in with a sketch plan every week and wanting us to redline it and do their work, I don't want to be doing that. So I kind of put it in, if it's optional, then it goes both ways. I don't know if you have any thoughts on that, Teresa. And we do actually have that on occasion.
Yeah.
Someone that wants to send by every, napkin drawing, and rather than hire professionals and work it out and then come talk to us.
I don't know how you do it. The other piece too is you all both know. Sometimes their engineer will do the same thing. Their engineer will just send you some draft and expect you to ask to red line and send it back to the engineer. I don't know how you get away from that, but yeah, that's a problem.
Yeah, and I think we're gonna work on that because this will be front loaded, meaning that there'll be a fair amount of engineering before someone actually submits an application. So the sketch plan is optional. They can submit it. We go from shall to should include the following because it's not a requirement. But encourage them to actually put some time into it. Again, these are just definitions in the subdivision ordinance. Okay, this is where the first item of significant discussion in the subdivision ordinance is this small subdivision, 10 lots or less. I don't think we need a smaller minor subdivision unless you want a different process. So I'll give you an example. In Weber County, unincorporated Weber County, they essentially have two processes. If you're doing 10 lots or more, you submit, and then the planning commission makes the decision on the subdivision. If it's 9 lots or less, and the number can vary, but if it's 9 lots or less in Weber County, then it goes before their land use authority for that size is the city engineer, the planning director, who's the official land use authority, and a planning staff. And so you meet with them, and they review it and they make that decision. And so I guess my question for you is, does Morgan actually want to have a separate process for a smaller lot? It could be 2 or 3 or 5, or it could be if you're dividing property, then we want it coming before the planning commission as the land use authority, and you see everything.
What's your preference, Teresa and Jake?
Say that again.
What's your preference,
I'm okay either way.
Teresa?
I think that it's a benefit when you have a small subdivision. For example,
Just one or 2 lots.
we
yeah.
just had one for the Strebeck that didn't come to you because there was no dedication to the city. It was a 2-lot subdivision. To encompass that, to come to you, and it's basically, it meets the ordinance, and the engineer goes through it with a fine tooth comb. And so coming to the planning commission is for what reason?
Yeah. My take is that same thing. If you have 1 or 2 lots, maybe 3 lots, I think staff is very, very capable of taking care of those. I don't think the 1 or 2 or 3 lots need to come to the full cycle. I don't know what that magic number is at this point, but I would think 1 or 2 or 3 is easily done by the staff.
So that means, the Anderton subdivision that we approved,
Yeah.
now that came to us.
Yeah.
And what you're saying in the future, we wouldn't have to be involved, it would be handled by staff?
And
Because it connected onto a state highway and all that? Okay, yeah.
This-
However, I would say for, updating the ordinance that the decision of whether it goes to planning commission or not is just based off of the lot size. That these other technical factors doesn't merit it to go to the planning commission. That's
Thanks.
a little bit more black and white. It's just the size. Is it 5? Is it 7? Is it 9? I
If
mean,
it's big, it's gonna be.
well, that's what I'm saying is if
Let
it's
staff make this.
10, whatever the lot number is or less, then the staff would be both their preliminary and final plat. If you choose to go that, rather than what Teresa said is, so we had the 2 or 3 lot subdivision, which was just dividing property, but because Anderton connected to State Street and a private road and some other things, then a little bit more complicated. That's where it gets kind of gray and messy. I would just say if it's a certain number or less, then we call it a minor subdivision. That's a conventional term used.
Teresa? Your opinion on minor, how many lots is? You're the one that deals with it.
I'm not sure what you would do that number, but I do highly recommend that you have a small lot subdivision that just stays with staff, and then the larger ones with the commission. But I couldn't tell you the size.
Would you
How
want-
many lots?
Would you want any language in that stating that, the discretion of the staff. It could be recommended for review by the planning commission if there were additional factors, or would that just muddy the waters? Would you guys rather?
Yeah, that'd be a good idea.
Leave it open, and if it gets a little bit too muddled, then it has the
If it-
opportunity to
It's
come
becoming
back.
more political, even though it shouldn't be political because you're not an elected body. Gary, any thoughts on that? I hadn't seen that before where it's like if the land use authority, meaning staff, could choose to send it to planning commission if they wanted. That could be a headache for an applicant.
And you wouldn't want anything to appear arbitrary, you know, how come I got sent and he
Yes,
didn't?
we like you, but we don't like them.
If he's ever said anything like that, you need the criteria. So the staff knows when it goes to
Yeah.
planning commission, when it doesn't, so it's not just like you say.
Yeah.
There'd be a trigger.
Yeah.
in a
And even
certain
if,
case.
like on the Anderton, it did come to you guys, but when you think about it, if you looked at your whole thing, did it really need to come to you? Because it was all engineering, it was all. There was requirements that you need to get from the state and those things, but they weren't a determination by the planning commission. It was just required documents and that's it.
Yeah.
So
Yeah.
it really technically probably didn't need to come.
I think given the size of Morgan, I would keep that number pretty small. No more than 5 and maybe even 3 is kind of where I'm leaning. I don't know.
Currently, one of the things that might help with determination is that on a private lane, you can have up to 5 units, so
Oh,
it could
okay.
be
That might be a good place to cut it off.
be a good starting.
That's a good. Are we okay with that? Yeah. Okay, I'm gonna make a note here. Minor lot subdivision. Staff as land use authority for prelim and final plat.
And this is obviously something that requires no zoning changes or anything like that. right?
Correct. 5 lots or less.
You own an acre. You're in the middle of town. You want to divide
You
it
want to
for
cut it into
4.
4, yeah.
That's what they're talking. It's already zoned for that.
That's what I thought, yeah.
And we still, the application may be different, it may be the same, I don't know. I'm not sure off the top of my head, but certainly we could identify that. They're applying for what we would call a minor subdivision unless you have I prefer the term minor. Small seems arbitrary and minor is what I've seen with other. So there'd be just your normal subdivision. We don't even need to call it major. It's not music. So you just have your normal subdivision and then your minor, meaning it's 5 lots or less. And whether there's a right-of-way dedication or not, it would still fall in that 5 lot. Is everybody okay with that? Okay. So this language will only need to change and we'll go through it, but that was something that I thought, okay, we need to discuss that and make that decision. We did talk about it last time. So I highlighted this, but I also saw it in a lot of other areas. So I'm maybe backtracking a little bit here is we have our engineering design standards that was adopted by the city. Essentially that, that's the code for engineering. Slopes, pipes, roads, utilities, all of that. But we also have a fair amount that's in the subdivision ordinance. And I don't know if there's been any discussion on moving everything that's more engineering design to the engineering design standards, or we keep some of these things here. But this is something that jumped out to me right away was like, why is this in the subdivision ordinance?
So,
Gary, do you have any thought on that? I don't know what you've seen at other cities in terms of having a lot of engineering technical items in the subdivision ordinance.
They're all pretty much the same as ours.
They mix both of them.
Okay.
The more technical it is, And the more specific it is, it goes into the specifications that are approved once a year by the planning commission, city council. But, yeah, I know the engineer looks to the subdivision ordinance for a lot of his particulars. I don't know how you'd make that division. You know, I don't know how you decide what goes in, what goes out, but it would be worth looking at and run it by Matt and see how many things he thinks should go into that other, you know, into the specific requirements.
Okay.
But, yeah, I know he uses this a lot. He uses the subdivision ordinance a lot.
Okay. I'm gonna make a note here to discuss with city engineer.
The one difficulty I was in is coming back, if the standards change and the state standards for water and fire flow, and the engineer's up on that, I'm not sure we come back and rechange we don't change this subdivision ordinance often enough to keep in sync with the state standards. Or do we?
I agree. No, I don't think we do.
You know, I haven't said it very well, you know what I'm trying to say?
Okay. So Gary, did you say that it's a requirement by Morgan City to a minimum of one time a year review and approve the design standards?
And I don't think they have to go to the planning commission. I think it just is the city
Yeah,
council.
just-
No, we've never had the standards come. I don't believe it. It does go. Planning Commission never has.
But I guess my point is to what Ray's saying is if there's a trigger that a minimum of once a year, the design standards are reviewed by the city engineer, which is probably the most important, and then the city council approves them, that means they're being looked at once a year, where the subdivision ordinance is guaranteed not updated once a year. So I think moving things that could change according to best practices or state standards or things like that, Department of Environmental Quality or water or whatever, putting them in a standard might make a little more sense.
Back years and years ago when Mark was here, Mark used to keep up on that, and every year he'd bring it before the council, we'd approve the state standards. Mark was very adept on that, had books and books on it. I'm sure the engineer does as well.
Yeah, and the fire chief does the same thing.
I'm sure, you know, they.
And what you're talking about, that was the design standards that he brought forward, not the subdivision ordinance.
Yeah.
Okay.
Right.
Okay.
But if they interface here, I think those standards would take precedence over these. Because they're reviewed and these are not.
Yeah, that's a good question. There should there be, do we need to, I don't know if it's in here, Gary, if we need to establish a hierarchy that if there's a conflict between the design standards and the subdivision ordinance, if one would be, take precedence.
Usually governs, but there's sometimes where, like, for example, our distance from a sewer line before you need to make a connection is 100. I think it may be one thing in the design standards and another thing in our ordinance and another thing in state law. So we need to bring that into compliance, but which one's more restrictive? I don't know. Is it the closer one that requires you to be closer before you have to connect? Or is it the one that requires you to be 100 feet further to connect? And right now, the state law is the more liberal one. It's
Imagine that.
yes, which is hard to imagine. So it's little things like that. That's just an
Yeah,
example.
anyway.
So, but it's the more restrictive that usually governs.
Yeah. Okay.
But yeah, I think that's a good example that we'll raise the question with Matt.
Yeah, this is very specific.
It is.
It's also affects the fire chief.
Fire chief's gonna pass that off based on his knowledge, not based on what our subdivision ordinance says.
Oh, that's true. The fire code.
Fire marshal's he's gonna pass it off and sign it based on what he understands the fire code to be. He's not gonna look at subdivision ordinance.
Is a fire marshal governed by the International Fire Code?
Yes.
So he has to go by that.
Yeah.
And the only ones that amend that every year are the state legislature.
Right.
So.
Yes. Okay, this one I was just also working on, any land divided for any purposes into 3 or more lots after the passage of this title shall be subject to the provisions and regulations herein, except the following, which are exempt therein. I think this is one I'll have to also work through with Gary. I wasn't quite sure what this was doing or if we even need this. So I'm gonna highlight, as I said, this feels like I'm revising the Old Testament.
So that was amended back in 2003. You're saying that you want me to remember what happened?
Yeah.
Ray or somebody that was alive during that period of time.
Yeah. There may be certain things that
20
served a
20
function
22
back
years-
then.
22 years ago, where were you?
I was in college.
Mm-hmm.
Okay. All right. This is where things again, there's going to be a lot of work here, but this is where we start to get into where we change. So for example, instead of, in a lot of cases where it says city council approval, that's now going to be planning commission approval. With the minor lot subdivision, Gary, how do you propose we do that language? Does it need to have, does it basically say, in any case that it says planning commission, you substitute staff for that? You see, we don't want to have a full second ordinance for the minor lot subdivision, but how would someone interpret that in where it says, the planning commission will do this and that? And in that case, it would be the staff land use group.
That's a good idea.
Could you just state that in your minor subdivisions location, that other references to planning commission would not apply to this group?
Yeah.
In the description portion of a minor subdivision,
Just make a statement up in that.
like have
I
that.
thought it'd work or not, Gary, that's just a thought.
Yeah.
Would that work?
Possibility, provided. that you'd have to look through them all and make sure.
You have to look at all and see and check
that
it
it
all.
works.
Somebody might make
Yeah.
it all of them.
I don't know which way it'd work, whether it'd be better to identify specific sections as changing whenever you have a minor subdivision, or whether you can do a blanket. We'll have to look. at
Yeah.
Whether or not it changes things.
And the ordinance could just say land use authority and then does this or that, and then
It's a better way of doing it.
you like, if that makes sense. So the ordinance would read that the land use authority does this or that, reviews the application, and early in the ordinance, it would state when is a staff a land use authority and when is the planning commission the land use authority.
So you do it in the definitions rather than, so instead of planning commission or staff, you put land use authority and then designate up front in the definitions.
In the definition.
When it's a small or a minor subdivision, it's the staff is the land use authority. And when it's a larger subdivision, it's the planning commission that is land use. Does that make sense or?
What do you think? You just have to remember when you're reviewing the ordinance, like, I'm the land use authority now.
I like it that way because then,
Okay, and maybe in the ordinance, there will be some clarifiers
yeah.
that, for example, on a minor lot subdivision, the staff would be both the preliminary and the final. But according to state code, planning commission can't be both. And what we discussed last time is that you'll be the land use authority for the preliminary plat, and the staff will be the final plat approval as land use authority.
In definitions.
We'll take a look at and see how,
Okay.
there may be a simpler way of doing it. This is the first look that we've had at this, so.
Well, we were hoping that, all those big cities that had to have this done already
I think-
would find all the errors and corrections and fix them all, and then we would just have to copy and paste.
Well, we could do that. I mean, that's the other idea. I guess that's a question for the planning commission. If we came back with an entirely new ordinance, would you be opposed to that? Or do you want us to? Well, yes, but also what were you saying, Mark?
Whole new subdivision ordinance?
Yeah, well, we're basically, instead of going through and making this all work and,
Do it all over.
we just basically start new. And also if somebody's already gone through and has a different approach, if that looks really good, then we just do a wholesale swap as well. But this is the history of Morgan too. There may be things in here that you love, that go back to pioneer days. I'm not seeing it. No, but
Before Gary and I were born, right?
there we go.
We could work on the original.
Okay.
So you're giving us permission to look over some children.
Yeah.
Yes.
I think that's a good idea.
Okay.
Well, and there may be just certain sections that are better, that another city has a better way of putting, but you can still keep the body of what you've got, most of what you've got, because a lot of it, yeah, Jake's right, you got history in here too.
Yeah. Okay. So this is one that I came and I was like, why in the world is this here? So you allow a protection strip. Let's just say, for example, if there's subdivision X and subdivision Y is coming down the road eventually, well, X at the end of his right of way, the end of his street, this allows him to not develop and not put in a road for 1 foot across the edge of the end of the road, so that he has, and that remains private. So he has absolute control. And there are some things in here about how it can be sold and all of that. So that when subdivision Y comes in, they have to pay money and work it through. And the reason for this is probably because you're saying, well, X put in all the dollars, put in the infrastructure, Y is connecting on, maybe he should pay part of that. Another way to do that is pioneering agreements, where the city says, we know that you're putting in this significant additional infrastructure. Those who come after you for the next 5 or 10 years will have to pay you a portion back. That's the way that other cities typically do this. I don't love this protection strip because it kind of says, if I'm going to build my sidewalk and you're going to come into the lot next to me, I'm going to have a 1 foot section here and I'm going to charge you money so that you can build in, rather than a city, grows infrastructure next to infrastructure. In some cases, cities actually prohibit protection strips so that you do, let's just say, for example, tonight we looked at where all these streets stubbed in. You would prohibit a protection strip so that whoever comes in can, immediately, once the subdivision's approved and construction docs approved, you can start building right next to it.
They should
Is-
be prohibited.
Yeah.
This is an old section and it really needs to be struck and they need to be prohibited.
So, okay, that's what I was thinking, was prohibit actually a protection strip rather than allow them. And any thoughts on that, or that okay? Maybe that's, we flip it. I mean, this was adopted in 1982 and I don't know why, but
Well, that was before a lot of the pioneer agreements came into being and
okay.
were justified back in the early 80s. You started to get the idea that you could have others contribute to it, and they started to put together pioneer agreements or payback agreements is what they call them. But,
really didn't do agreements at all.
right,
It was all had to be yours.
yeah. But this is, yeah, you want to get rid of that and you want to do the opposite. You want to make it illegal to have that. That's just my opinion.
Reading that first line, I guess what brings to my mind is where subdivisions, streets parallel contiguous property of others. And I think we have other things in place to take care of that. For example, if your property and properties are against a parallel street that then goes into a commercial area, I can see why you need a buffer there. At this point, we require fencing. So our requirement of fencing maybe takes care of that situation.
Yeah.
If that makes sense. So I can see what, if that's talking about between private property and a commercial area.
I think though, in our ordinance, we also have, buffering, like
Yeah,
landscape
right.
buffering
I think that takes care-
requirement, of fencing buffering requirements between residential and agricultural, and then residential and commercial. So I don't
Wait.
know if
I think the buffering takes care of this.
This isn't addressing any of
Any
that.
of
What it's
that.
addressing is ownership of land
ownership.
Oh, really?
and title to property. And
An ability to access.
it's saying you can block somebody by,
Where's an example in town?
I
Of
don't
one of
think we
these?
have one of
I
those.
don't know.
Have any?
I guess that maybe that's why it's still here, because it wasn't an
Okay,
issue.
I'm not following.
Yeah.
well, what happens is, for example, where you got the Turner subdivision and you got 525 that comes, 525, right?
Yeah.
That comes up to the Turner property in Pheasant View. So you require that the Pheasant View keeps 1 foot right at the property line in their ownership, okay? And so you got this public street that goes all the way up to Pheasant View's 1 foot strip. And then you require the Turners to access down that road. That's their second access for their property. And so the Turners now are forced to come to Pheasant View and say, please sell me that 1 foot strip. And Turners say, well, what's it worth to you? You know, and so they develop a price, and you can literally hold the other side hostage and not allow them to develop. If that was the only access that was available to them, and they had that 1 foot strip at the end that they retained ownership of, you're done. You can't develop. You could not develop your property. And we've got it right now in Layton where, I won't tell you how it happened, but we have a developer that dedicated the entire road. And unfortunately, the road was, in order to align, had to move a little bit further north, which left a 10 foot strip between the roadway and the church's property. Church has 107 acres of property. And they want to develop that into a Market Street type, with apartments and marketplace and that type of thing. But they can't get access over that 10 foot strip because he owns that 10 foot, it's a protection strip. And he's refused to sell it. He's refused to, the city can't condemn it because it's not part of the road. And so essentially, he's locked that 107 acres up until such time as he, puts the church over a barrel and says, I want, 10 acres of your property from you to be able to get access now, all up and down your property. And it's a main arterial street, and that increases the value of their property or decreases it based on whether or not he sells that strip to them. That's what this does. That's the reason we prohibited it. But we didn't prohibit it back when this was created, so.
Okay.
So anyway, does that help?
Yeah.
Yeah, okay. So, yeah, we'll flip this. It was eye-opening to me. Okay. And again, we don't have to go through everything tonight. I've just highlighted some things in yellow. I don't know how long you want to go as well, but this was another item which I really wasn't quite sure. This says that if there's an appeal, then you can take it to the city council. If you come to the planning commission and you don't like how they voted on your subdivision approval, then you can take it to the city council. I almost wonder if this just followed the city's typical appeal authority process.
It did. We'll have to change that so it's consistent with state law.
Okay, so this should just change to follow the city's appeal ordinance, and we'll also make sure that's consistent with state law.
Because our
Okay.
appeal
S-
things.
so-
Appeal authorities.
Yeah. No, I think that we amended it when they changed from a Board of Adjustments. But how long ago was that? 12 years? I was here when there used to be a Board of Adjustments. So it's got to be less than 15 years since we did that.
Yeah. And-
So again, this one was 1982.
Cool.
I can't help but wonder how many developers have ever been scared them
There's a
away.
lot you could do with this, actually.
Back then, that was a process for appeals.
Yeah.
Back then, it was appropriate.
Yeah.
We've just changed the appeal process and never changed this.
Yeah. Who's still driving a 1982 Ford?
We had appeals board for adjustments. And I was on that when I first started.
Oh, that's cool. Okay,
I
Okay.
I can still remember the one we dealt with.
okay,
Janitor versus Freddie Jacobson. Try that one on.
What's the answer?
Janitor versus Freddie Jacobson.
Wow.
well,
Not one of the people.
okay.
Sounds like there's some pretty major revision that needs to be done.
Yeah, there
here.
is.
Are you leaning towards fixing what we've got or seeing if you can find something cleaner and newer and start all over?
Hybrid, if there's
Okay.
certain things that are like, well, let's just say that part about the, whatever we call
Strip.
yeah, protection strip. We just add a simple section that we prohibit it. And essentially, I think it's, you use the term prohibiting the protection strip, but then you also say connecting right of ways and all of that. So I'm kind of leaning towards a little bit of a hybrid, maybe. Maybe we don't need to spend as much time tonight hacking stuff and rather come back with the new stuff.
On the protection strip, do we need to put in the verbiage of prohibited or just take it out totally so it's not even, protection strip's not even addressed in there?
I think you need to prohibit it.
Yeah.
Otherwise,
Okay.
somebody's gonna try to do it, so.
Yeah, we want to prohibit it. And the other thing I think we want to require is street connectivity, like requiring some streets, but also stubbing in cases. We already have that a little bit, but I think it can be even more. I'll show you an example I was looking at earlier. Particularly, this street right here, what is that, 275? The fact that there's a cul-de-sac there. I would rather that just have been a dead end or an open street connection rather than,
And that,
there's a big field right there. It's likely that someone at some point would want to develop that.
Yep.
So I think we get to more, if there's open ground, let's just provide in future stubs.
that was heavily discussed in that direction by staff. But the landowners didn't want to do that, so the staff's okay, if you don't want to do that, then we'll let you do the cul-de-sac. So your idea was what staff wanted to do.
But what we
Those
can do is
property owners don't
actually
want to.
force it. And I think that's where, at the city, I mean, you're a planning commission appointed by the mayor and city council. And our job is to look out for the best interest of the whole city. I realize that living here on the end of this cul-de-sac would be awesome. Kids could ride around and never even think about vehicles or all of that. Maybe higher property value. They don't like their neighbor, whatever. But we can just say there's open ground there. Let's do that. And the other thing, even with Canyon Creek, we could require some stub ups. 20 or 30 years ago, Morgan wasn't thinking about how do we cross Weber River. Now that we're looking at the Clark Dairy property, which could have a change over the next decade, you have this Long Island Road, and then you have Weber River, And how do we connect these two big parts of the city? And if there's just a couple stubs every so often, then you have options, whether you require a bridge or not.
You mean to tell me you wouldn't approve Island Grove?
No, I wouldn't. It seems like the,
Morgan's famous for that, though.
it's the world's largest longest cul-de-sac.
When I explain people, the downlanders, when I explain them what Island Road is, they're like, what? Oh, yeah.
Why is it called Island Road?
It's
Well,
an
because
island.
it's between the creek and the river.
Yes.
That's,
Okay.
that's not different than the road from the fairgrounds to the golf course.
Yeah, same thing, we got two of them.
Yeah, let's do that.
You develop that road along the golf course, you got the same thing.
Have your comments.
Okay.
Can you send us a
Huh?
copy of that?
Yeah. Why don't we do that? Well, I'll provide some instructions as to recommend that you go through it and you highlight areas that you like and you don't like. I'll add my comments. It'll be a working document. In fact, what we can do is I'll make it an online document so that everybody can see everybody else's comments. Essentially like a Google Doc, except for it'll be a Word online. I think that'll be great that people can actually collaborate and you sign in and it says who says what. Does that sound good? This gives you, we dived in enough that you saw a taste of this big casserole or whatever you want to call it. Yes.
Well, we still have this. Okay.
You know, and this is just stuff I recommend that we just, yeah, because really you don't have, you've got your 3 missing people.
Meeting adjourned, everybody go home. No.